Good morning, everyone. It's not a huge crowd, so feel free to introduce yourselves in the chat if you feel like. It's always good to see who is in the call. Well, we are here today for the lunch, for the weighted lunch of a very interesting paper, implementing tips, flexibilities to improve access to medicines. And we are extremely lucky to have with us like the author of the paper, Dr. Praniti Parwani, and also someone who knows a lot about the topic at hand, Thiru Balasubramanian. I'm going to be going over their bios later on, but I would like to explain how is it going to work. We're going to have a very brief presentation by Praniti of like 10, 15 minutes, and then we'll have a response by Thiru that is going to be like more or less like 10 minutes. And then we're going to have like an exchange, questions and answers. I have prepared some questions in case there are none, but I'm sure that there is going to be like comments and observations as we are talking about something that is extremely relevant like today. And it's going to be part of our work and discussions for the next like couple of years. And like talking about work and discussions, I really would like to mention two points which I believe are important. First one is that this paper is part of like a longer series of materials and products that HI has been working on for the last even like maybe 10 years around the issue of like health-oriented IP management tools and access to health technologies that include like work on the TRIPS flexibilities, but also other issues related to IP and access to medicine. And also, I think it's important to mention that this paper is possible, has been possible, uh, thanks to the support of United. HI is part of a consortium called like Medical Innovations for All, like funded by Unitate, as I said, and led by BEMOS with the participation of like BEMOS, of course, Knowledge Ecology International, Medicines Law and Policy, Universities Allied for Essential Medicines, Innovarti, and Haki Foundation. I'm extremely happy to see representatives from several of these organizations among the participants today. I'm going to start now, like the presentation of this paper, by really going a little bit over the bio of Praniti Parwani, who recently defended summa cum laude her PhD at the University of Amsterdam, where her research examined the EU and India's legal and regulatory influence on access to pandemic vaccines in least developed countries. In January 2026, she will join the University of Warwick as an assistant professor in global health law. And I really like this idea of like nonprofits or civil society organizations joining forces with academics to produce this kind of papers. And with like no more like talk on my side, I would like to give the floor to Pramiti that she's going to share a slide screen with us so she can really like go over this paper. Pramiti, the floor is yours.
Thank you, Shame, for that introduction. Just to confirm, you can all see my slides. Okay. So as Jaume said, this is a part of a larger series that HI has been working on, and this project on improving improving access to medicines through facilitating and further expanding the use of TRIPS flexibilities really takes a holistic, coordinated, multi-stakeholder approach. So it argues for action on three levels: domestic, regional, and multilateral. But more importantly, it also argues for coordinated action amongst governments, civil society organizations in different parts of the world, internationally as well as domestically, etc. So, a little bit of background to this brief. The brief is now live on the HI website, so I really encourage all of you to check it out. a little bit of background, this builds a bit on work that HI has been doing over the past years, as well as excellent work by other civil society organizations, including Knowledge Ecology International and Medicines Law and Policy. It also builds on my PhD dissertation that Jaume just mentioned, as well as another paper that I wrote with Geraldo Vidigal about the interactional nature of TRIPS flexibilities, which essentially means that TRIPS flexibilities and their use is not just impacted by the black letter of the law or the black letter text of the TRIPS agreement, but very much about through the interaction between different actors such as countries, regional organizations, international organizations, and how they interact and accept or contest or accommodate the use of TRIPS flexibilities. So first, I would like to highlight some of the constraining factors that we've seen, factors that constrain the use of TRIPS flexibilities in different parts of the world. And after discussing that, I will then go into the three-level action framework that we propose across the domestic, regional, and multilateral levels. So, first of all, the for one of the factors that we found was the lack of legislative incorporation in both domestic and regional legal frameworks. So, what that means is that while the TRIPS agreement provides these flexibilities, it is up to states and, in some instances, regional organizations to really implement them by incorporating them in the law. So, as an example, while most least developed countries have implemented the transition period that they have under the TRIPS agreement, there are a few countries which have not done so yet, which means that they continue to grant patents for pharmaceutical products, for medicines, even though they don't need to do so. As an example, is Djibouti and Malawi, who still provide patents for medicines, and that, of course, impacts and constrains access to medicines in those countries. Um, we've also seen that regional frameworks, for example, regional organizations such as the IP offices in Africa, the ARIPO and the OAP, which are the Anglophone and Francophone countries' IP offices, can also have an impact on whether TRIPS flexibilities are incorporated or not. So, until recently, OAP, which is the IP office for Francophone African countries, did not incorporate the LDC transition period for their countries. But that has now been rectified as of this January of 2025. So that's positive progress in that. A second constraining factor, also, as I mentioned previously, is the unilateral political and economic pressure that we often see from other states, from pharmaceutical companies, etc., when countries either issue compulsory licenses, in many instances, even when countries are simply exploring the option of compulsory licenses or exploring some amendments to their legislation to facilitate compulsory licenses, we've seen that that has often been met with a lot of backlash from other countries, also from pharmaceutical companies. One of the most notorious in this regard is the United States through its 301 report. And Thiru will also talk about this in more detail in his speech, but we saw that in 2007 and 8 when Thailand was issuing compulsory licenses for various medicines, or in 2013 when India issued a compulsory license for a cancer drug. In both those instances and in many other instances, the US the US essentially mentions these instances as reasons for blacklisting or putting these countries on the priority watch list through its 301 report. Also, at the beginning of 2020, when the Dutch government was exploring compulsory licensing as an option to expand access to medicines, the US wrote an open letter essentially uh, pressurizing the Dutch government to not take that step. We also see that this kind of pressure often also comes from the European Commission through its IP enforcement reports, as well as from pharmaceutical companies when their interests are affected. So, again, in 2008, when Thailand issued a compulsory license, Abbott, the pharmaceutical company, threatened to blacklist the Thai government and say that it would not introduce any new measures in Thailand. So, we see that Unilateral political and economic pressure can often be a huge constraining factor that affects the use of TRIPS flexibilities, even though, as per the black letter of the TRIPS agreement, those flexibilities should be available to all countries. Third, and this is, I think, quite an interesting aspect which has not been dealt with or addressed in a lot of detail in academic literature very often, but IP maximalist training, for example, from WIPO or from the European Patent Office or the US Patent and Trademark Office, and administrative cooperation between patent offices can often be a site of immense regulatory influence that essentially impacts how countries and their patent offices implement the TRIPS flexibilities on a day to day basis. So, for example, the WIPO has previously been criticized that the training and the technical assistance that it provides to patent offices in the global south countries is extremely IP maximalist, with not enough incorporation or with not enough sensitivity to the different health concerns and the TRIPS flexibilities that exist and that countries can incorporate to address these. Just as an example, the European Patent Office signs a validation agreement with many countries, including with LDCs like Lao, PDR. As a part of these validation agreements, these countries are essentially supposed to just validate any patents that have been granted by the European Patent Office. It's interesting to note that this is not a two-way street. The EPO is not supposed to validate any patents granted by Lao, but it's only a one-way street where Lao is supposed to validate the patents granted by the EPO. Now, this means that even where the EPO grants a pharmaceutical patent, Lao also has to do that, even though it's not needed, it's not obligated to do that under the TRIPS agreement. And finally, as we've discussed, and as we've seen in many instances over the years as well, TRIPS plus measures in free trade agreements can often be a constraining factor as well. We saw this in the FTAs that the US signed in the early 2000s with Singapore, Jordan, Australia. We also saw this more recently with the CPTPP, the Comprehensive Trade and Pacific Partnership Trade Agreement. I think I've messed up that acronym, but essentially, for example, that agreement includes patent linkage provisions, which link patent terms with regulatory approval and so limit the use of TRIPS flexibilities and have TRIPS plus obligations essentially under these FTAs. In the recent years, we've also seen a new kind of template emerge, for example, through India, which has usually been quite successful in pushing back against TRIPS plus measures and FTAs. But now, for example, the FTA that it signed with the UK recently or with the EFTA last year includes a provision which says that voluntary licensing more than compulsory licensing is to be the preferred mechanism. So, in a nutshell, these are some of the constraining factors which impact the use of TRIPS flexibilities by countries. And essentially, looking at this holistically, we propose a three-level action framework, as I said, at the domestic, regional, and multilateral level. At each of these levels, we argue that it is essential for countries, for governments, but also for civil society organizations, both local, regional, and international, to work together to address some of these challenges. And so we propose this three-level framework. I'm not going to discuss each of these steps in detail. I encourage all of you to read the policy brief, which is now available on the HIE website. But essentially, of course, then at the domestic level, it is important to incorporate all the available TRIPS flexibilities in national legislation. These flexibilities should be included in a health sensitive manner. So, for example, India now has this the Indian patent legislation is quite noted for its anti evergreening provision, which essentially means that the second use of a known patent should not be patented. So just a simply an it should have a substantial innovation. Now we see that these kind of anti-evergreening provisions have also been included in legislations from other countries, for example, in the Bangladeshi Patent Act of 2023. I think that this is a wonderful example of South policy diffusion and should be expanded to other countries as well as more full incorporation of TRIPS flexibilities and all available flexibilities in a health sensitive manner. As I said, this is an example of South policy diffusion, and one of the ways in which this policy diffusion can further be expanded is through collaborations between patent offices. We see right now that a lot of collaboration, technical assistance, and training often flows in a very unidirectional manner from the global north. So, for example, from the EPO or the US Patent and Trademark Office to patent offices in the global south, but there is a space and a need for more collaborations in a south manner, because these are countries which often have similar challenges, can have similar learning curves from incorporating and from implementing the TRIPS agreement, etc. As I said, civil society can have a huge role to play in this. In Africa, at the ARIPO, which is the IP office for Anglophone countries, we saw that civil society organizations had a huge role to play in reforms that came about a few years ago, reforms that essentially expanded the use of TRIPS flexibilities at the regional level there. We've also seen that patent civil society organizations can play a huge role through patent opposition filings as well as strategic litigation. Then at the regional level, again, it's extremely important to include all the available TRIPS flexibilities in the regional IP frameworks. Where regional IP organizations have LDCs as member of these organizations, it is extremely important to make sure that the LDC transition period is included in that. And it's important to ensure that where we sign free trade agreements, they don't include TRIPS plus measures. Again, as I said, regional CSO networks have a huge role to play in this, as we saw from the example of ARIPO. We also see that civil society oversight in regional trade negotiations can serve as a very important counterpoint and counter narrative to trade pressure from the global north countries. And then finally, at the multilateral level, we've seen now that the pandemic agreement includes a provision which says that countries must respect the use of TRIPS flexibilities. But there is space and the need to go beyond this as well. We'll discuss about this in more detail over the question and answers as well. But there is a need, for example, to have some kind of commitment in the TRIPS agreement, which ensures that countries are not able to place unilateral pressure on each other to constrain the use of TRIPS flexibilities. So the use of TRIPS flexibilities should become more than just what it is right now, which is an it is an opportunity for countries, but this interactional element where pressure from each other, from pressure from other countries can have a constraining aspect, should also be dealt with under the TRIPS agreement through reform and review. For example, Colombia started a review process at the TRIPS Council. We've seen very mixed and limited success of that, but I think that is an important avenue that we must keep exploring for multilateral reform to expand the use of TRIPS flexibilities, especially with the lens of pandemic preparedness. And when the next pandemic hits, we need to have these kind of measures in place already. Regulatory preparedness is also an integral part of pandemic preparedness, and we need to have these kind of reforms again at the domestic, regional, and multilateral level to expand the use of TRIPS flexibilities so as to ensure access to medicines. That brings me to the end of my presentation. I'm happy to hear comments by Thiru and then questions from all of you as well. Thank you.
Thank you, Pramiti. I have to say that I admire greatly the people that are able to condensate so much information in such a short space of time. I think that that's a skill and ability that really it's hard to replicate. Thank you, Pramiti. I think that it's a really good introduction to the paper and also invites to like plenty of other topics of discussion. I will give the floor now to Thiru, and they will open the discussions because we have some people among the participants with direct participation and involvement in these processes. So I think it's going to be interesting. Regarding Thiru Balasubramanian, he is the Geneva representative of Knowledge Ecology International. He holds a BA in economics and minor in European history from the University of Pennsylvania. He has represented KI in various multilateral fora, including the Marrakesh Diplomatic Conference to conclude a treaty to facilitate access to published works by visually impaired persons and persons with print disabilities, the WHO Intergovernmental Committee on Public Health, Innovation, and Intellectual Property, and he also follows and monitors discussions at WTO TRIPS councils. And today he is joining us from the very WTO building, which I find it really impressive. And I think it's interesting because Thiru has this ability that he's following processes at the three levels in Geneva, like WIPO, WTO, and WHO, so makes his insights especially informed. Thiru, you have the floor. Thank you.
Thank you, Jama. Can you hear me? Yes, so thank you, Hai, for your invitation to respond to Dr. Pramita's detailed three-level action framework on implementing TRIPS flexibilities. Pramita, in your analysis on domestic use of TRIPS flexibilities, you rightly point out that while the United States often aims criticism of third countries for exploring even the possibility of issuing compulsory licenses, the US itself routinely employs compulsory licensing and government use, most notably after the 2006 eBay case. So what we see is certainly a case of cognitive policy dissonance. So just to dive in a bit more, the US, following the 2006 eBay case, every patent infringement case in the US is a potential compulsory licensing case if remedies for infringement are decided by a court. Before an injunction can be granted, a judge has to evaluate 4 factors. And to obtain an injunction, the plaintiff has to demonstrate, and I'll just briefly go over the 4 factors. The first factor is that it has suffered an irreparable injury. The second factor, that remedies available at law are inadequate to compensate for that injury. Third, that considering the balance of hardships between the plaintiff and defendant, remedy and equity is warranted. And finally, that the public interest would not be disturbed by a permanent injunction. So in several of these cases where a court has decided that it is more equitable to permit an infringement going forward, the remedy is limited to the payment of royalties to the patent holders. These running royalties cases have benefited a number of businesses, such as eBay, Apple, Microsoft, Abbott Labs, Johnson & Johnson, and Toyota, for example. In your paper, Pramiti, in the brief, you also reference a KI briefing note from 2022 entitled Selected U.S. Government COVID Contracts with Authorization and Consent to Non-Voluntary Use of Third-Party Patents. And I will just go deep into this briefing note, which was prepared by some of my KI colleagues, including one of them who I believe is attending this seminar, Ariana Schouten. So in the briefing note, it showed that this review of contracts between the US and private companies to provide countermeasures for COVID illustrated the simplicity of the legal mechanism used by the federal government to eliminate exclusive rights to use patented inventions for federal programs, and the surprising frequency that this was done for COVID-19 countermeasures. Under the Freedom of Information Act, we obtained a number of R&D and procurement contracts for COVID-19. Many of these contracts contained significant reductions. However, for 62 of these contracts, we were able to identify language related to the government authorization to use the patented inventions without the permission of the patent holders. So among the 62 contracts, 54 provide a broad authorization to use any US patented invention. 5 contracts authorize the use of inventions that were not, and I quote, commercially available to the public by the recipient, end quote. So basically, the authorization to use patents for the government can be made by any agency in the federal government, and the authorization can be oral or in writing, express or implied, broad or limited. So during the pandemic, I would say, we would say the best known case involved one involving the Moderna vaccine, and the government's authorization was highlighted by Moderna in court filings related to the infringement cases by third parties in this case. A lot of these authorizations involve the use of and consent set out in revisions of the Federal Acquisition Regulation, FAR 522271, which was used as a template for contractual authorization or simply referenced in a contract. And some of the beneficiaries of these government use authorizations include well-known companies such as Corning, Lilly, Merck, Moderna, Novavax, Philips, Sanofi, and Siemens, as well as many small companies and a few universities. The contracts were for countermeasures including vaccines, drugs, diagnostic tests, and other technologies. In each of these cases, the authorization is broad, done without naming specific patents for which non-voluntary use is authorized, and applies to patents that may be granted at a later date and does not require prior negotiation with patent holders. And the US and the government assumed responsibility for compensating patent owners, if any, who could demonstrate their inventors were used by the contractor. Now, switching gears, if I may, to the current conversation at the TRIPS Council, it might be good to remind ourselves that calls for a review of the TRIPS agreement did not originate in 2024. As far back as February 2001, so basically 9 months before the Doha Declaration, Dr. Subhachai Panichpakdi, the Director General Designate of the WTO, made the following call at a WHO expert meeting at Chulalongkorn University in Thailand, which I happened to be part of. And the meeting report notes this, and this is from a WHO meeting report, and I'm just going to read a part of it. Narrowing down his remarks to address the TRIPS agreement, Dr. Supachai noted that TRIPS had only entered the trade talks during the Uruguay round, and that it was quite possible that at the time, developing countries had not fully appreciated its probable impact. And he said, Thailand has suffered in this process, he said. One government came down over the question of IPR rights. It was extensively debated in Thailand and in many developing countries, and there are a large number of countries around the world who think we must review the TRIPS agreement. At the moment, this is partly being done in Geneva. Some countries which cannot meet the commitment of the TRIPS agreement are now vying for support to revise TRIPS before the next round, the 9th round, which will commence sometime this year. Remember, this was 2001. There's also some kind of movement to look into the consequences of TRIPS, particularly in developing countries. And the report notes, clearly aware of how his pronouncements were being received in various quarters, he remarked, people keep reminding me that I should act as the incoming DG, not as a former deputy prime minister, because I would have to serve all the countries. But I will not relent in my criticism of countries which still think in terms of a few decades ago, while we are in a new millennium, end quote. So coming to most recent developments, on October 30th of this year, Brazil, Colombia, India, and South Africa submitted a paper or proposal to the TRIPS Council to convene technical, informal, and in-depth discussions at the Council on various issues, including, and I'll just name two, the WHO Pandemic Treaty and the WIPO Treaty on Intellectual Property and Genetic Resources. In relation to the Pandemic Treaty, the demandeurs asked, can WHO provide a presentation and information about the recently concluded pandemic agreement? What are the linkages it has with respect to the TRIPS agreement and IP issues? What are the provisions for the technology transfer in this treaty? How does it support access and trade of IP protected essential medical products in case of a future pandemic? And then just on the last, the other topic on the WIPO Genetic Resources Treaty, Brazil, Colombia, India, and South Africa asked, in the context of WIPO's treaty, can WIPO provide information and presentation on key provisions of the treaty, its linkage with the TRIPS agreement, if any? How would the adoption of the treaty be helpful in addressing the trade of biopiracy goods? So I think I'll end with that. And as Jaume noted, there are, I believe, people attending this seminar who are more closely connected to these discussions who might be able to provide some candid remarks as well. Over. Thank you.
Thank you, Tiro. That was really nice. I really like this stroll into memory lane, in the sense when 2001, when everything seemed possible, and now here we are trying to change the same text. I think it's really connected with what Pramiti is saying, in the sense that you have the letter of the treaty, then you have the spirit of this treaty, and we see how trends repeat themselves, in the sense technical cooperation is never, let's say, agnostic. There's always an agenda behind that. And also, I think it's very interesting how you mentioned the different processes that are going on at the same time. We are talking about the pandemic accord. We are talking about how do we share or access biological material, and we have WTO trying to catch up with all these processes while dealing with very serious internal crisis after the US working out. So I have a couple of questions for our panelists, but I don't know if anyone has a question. You can ask it or you can write it on the chat. The only thing that I ask you is to introduce your name and the organization you work with. I've seen there's a comment from Mark Biot from MSF. Another strong South-South collaboration is managed by Tilburg Network with support of the Egyptian Patent Office, who is very strict in analyzing patents and very willing to support regional colleagues, like this South-South collaboration that Pramiti was mentioning as possible way forward. I don't see any hands. I don't see any comments. I'm going to be asking a specific question to some of the participants, but first I would like to hear from Pramiti itself. The use of these flexibilities to improve access to medicines is now considered another policy option for governments. However, it remains a cumbersome exercise open to political pressures, as you said, reprisals. Can the TRIPS Council address such an undue pressure as part of the dispute settlement framework, also under pressure itself? Thank you.
Yeah, I think that's a very interesting point, and I think that's definitely necessary if we want to expand the use of TRIPS flexibilities in a more sustainable manner. One of the options for reform that I provide in the policy brief as well, of course, is that you have a reform of the TRIPS agreement where you include another provision that is essentially something along the lines of what was intended to be provided in the pandemic agreement in the first instance, which is that it includes an obligation on countries to not pressure or otherwise exercise any sort of unilateral pressure or otherwise stop countries from implementing TRIPS flexibilities. And the benefit of including this as an obligation under the TRIPS agreement would indeed be that it is now then open to TRIPS WTO dispute settlement essentially, that the dispute settlement body can then say to a country that you have violated your WTO obligations by exercising unilateral pressure intended to discourage another WTO member from not implementing a TRIPS flexibility. Of course, one thing in this is the political will, and as we see that reform of TRIPS agreement, we've heard, and I know Nicholas also has his hand raised, so I'm sure we'll hear something from him as well about the Colombian proposed review. The other thing that I would like to point out, of course, is that the WTO dispute settlement body itself is undergoing a huge crisis right now with the paralysis of the appellate body. We've seen that there are alternatives like the MPIA, which have come up and have been used by some countries, but by no means is that a perfect replacement of the appellate body. So there is still the threat that any country could just appeal into the void, essentially, which means that they would not, the result of the WTO panel would not have any result at all. And so that's something to keep in mind as well when we have these kind of discussions. Thank you.
Thank you, Pramiti. I think it's really interesting what you said, and I'm going to make like another question, like following up that you mentioned in the sense, yeah, we would need to change like the text of the TRIPS agreement, but I think that you already mentioned, but the difficulties already to get an agreement on 51Bs. And I think like the issue, I think it's not only like a matter of political will, but like it's also a matter of like the balance of forces in WTO, and it seems like that it's really difficult to change things. So I think for me, like my follow-up questions would be: is there any possibility to put pressure on WTO from regional settings to have like a group of countries, say like African countries or Latin American countries, like teaming up to advance like a reform agenda?
Yeah, I think absolutely. And I think in this sort of a scenario, as we've seen many times over the past years, having some kind of critical mass where many countries, whether on in terms of regional grouping, or global south countries more generally across regional barriers as well, when they come together and have some kind of a critical mass, it becomes much easier for them to push for their positions. I think what's crucial there is also to then stick to that position, and for some countries to not sort of give way, because there is always going to be counter pressure from global north countries as well. So I think the key thing is really to stick together and to band against that kind of pressure. Just one thing I think that the WTO remains a very important forum for this, but there is also something happening outside the WTO, which is what I termed as the interactional nature of TRIPS flexibilities earlier. And in that, we've seen that TRIPS flexibilities have increased and have gone through a spike during, for example, the HIV/AIDS crisis. And at this moment, using compulsory licensing or another TRIPS flexibilities for HIV/AIDS is much more acceptable than, say, using it for cancer or cardiovascular diseases, etc. We've also seen now high income countries use it. All of this to say that continued use and pushback against the sort of pressure from global north countries is also important in setting that counter narrative. And we've seen that that can lead to a kind of acceptance or accommodation. And I think that's why it's important to keep pushing back, to keep using TRIPS flexibilities, because over time that builds up and makes a very strong counter narrative that we see can then further expand the use of TRIPS flexibilities. Thank you.
Thank you, Pramiti. Very clear, and I think it's also true what you're saying, that we like there's this kind of association of like these flexibilities with antiretroviral medicines, and when Thailand, for instance, like made the first step, like announcing like compulsory licenses on non-communicable diseases, was kind of a shock for like pharmaceutical companies. So really good point. And now I have a question for Thiru, like regarding what we were saying, like the different process going on. We talk about the need for coherence between the national, regional, and global approach regarding TRIPS, especially flexibilities and tech transfer. And I would like to know, from your vantage point, you are following now the Intergovernmental Working Group on the Pathogens Access and Benefit Sharing at WHO, and you were very active also following the pandemic core discussions through the IMB. I would like to know, in your opinion, if the pandemic report negotiations is like a good example or a missed opportunity of the coordination of these three levels.
Dear John, thanks. I think, yeah, to respond bluntly, it was a missed opportunity, frankly, because I think in the wake of both the WTO response to COVID and the discussions on a potential waiver, and then subsequently at WHO in specific negotiations on transfer of technology, we saw a lot of this similar red lines come in, and I would say that the positions of the European Union and other, let's say, G7 or G6 plus countries were quite disappointing, and I believe we are seeing some of the same red lines prop up in discussion of the pathogen and access benefit sharing annex, and I think it's the G6 countries, G6 plus, are still quite dominant in their positions. Just one other thing that you mentioned just briefly, you were talking about, and Pramiti talked as well about, when Thailand, over almost 2 decades ago, issued compulsory license on, I believe it was a Sanofi drug. It was on non-communicable diseases. At around that time, actually at the request of the Thai government, we convened a small briefing session here in Geneva, and we invited various stakeholders, including IFPME, plus like representative countries. And I remember, because I wrote a meeting report about it as well. But one of the things said by France at that meeting in Geneva at our office was that, oh yes, compulsory licenses, they're like a nuclear deterrent. You should never actually use them, was the, wink, wink, hint, hint. So I thought that might be of interest. Over.
Thank you. And I see really like this being totally plausible. This like, oh, it's so extreme. It's so like last recourse. Okay, I see hand raised. Nicolas, you have the floor. If you can introduce yourself, thank you.
Thanks a lot for this invitation, and thanks Pramiti for a very good presentation and for an excellent paper, and Thiru as well for his excellent comments. It's true, as you said, Jaume, that Pramiti has an ability to condense very difficult information in a very straight and simple way. So I highly commend her for that. I just wanted to propose, or maybe to suggest, two further venues of exploration from this point on. One is related to the pressure that countries receive on when they try to use the flexibilities. And there is a new WTO decision that has been made by the MPIA, this transitional arrangement to replace the appellate body, a decision on on a case brought by the European Union against China on intellectual property issues. It's a difficult decision. It created a sort of non-frustration standard that has been heavily criticized as it expands the extraterritoriality of the TRIPS agreement. But it might have a silver lining in the sense that this non-frustration standard can be used as a counterweight for that pressure that countries have when they try to use the compulsory licensing schemes. So an exploration of that decision, not just from the perspective of the ones trying to protect more their rights, but also from those that want to protect their flexibilities to use those rights. That non-frustration standard can be used both ways, probably. And the second comment is that there is this Article 40 of the TRIPS agreement, which is very complicated, very difficult to read, never used, but it might have an extra space for flexibility that can be used at the domestic, at the regional, and at the multilateral level. So it warrants a potential exploration or discussion, and I would love hi Jaume Pramiti to maybe take a look at it. Thanks a lot.
Thank you, Nicolas. I really like this idea of really follow up to this paper, but because it's true that there are many topics that are worthy exploring, and now that I have you here, and it's not putting you on the spot at all, it's really if you could share with us the experience like the experience of the Colombian government and the Colombian mission trying to really get this evaluation of the TRIPS agreement, trying to get the TRIPS Council to address some of the most salient issues that it has for not only like least developed countries, but also like middle income countries and even some high income countries.
Thanks, and no issue with the spot. uh, the use of compulsory licensing by Colombia has been quite difficult, and it's been quite difficult because of something that Pramiti rightly highlights in the paper and in the presentation, because of pressure. We did have a regulation ready for compulsory licensing. It could be better or not, but we did have it. And we tried to do compulsory licenses 3 times in the past with no success. So we had a case related to Caletra for HIV 10 or 15 years ago, which was unsuccessful. Then we had a case related to Glivec, which is an antihepatitis medicament, and we couldn't as well. There was some sort of a different solution at the end, but we couldn't use the compulsory license. And we do have a new case which was successful related to dolutegravir, which is quite recent, but it's a very narrow and limited use of compulsory licensing for a medicine which is patented for just 1 year, 1 extra year, and just for a special type of importation and just for the Venezuelan population inside Colombia. So it was a very narrow type of compulsory licensing, and still it's been sued all over the place. It's been challenged all over the place. Suing it's okay, but pressure by governments has been quite harsh, even if it's a very narrow type of measure. So pressure is there. And when we try to do some sort of anti-pressure clauses in the pandemic agreement or at the WTO, it's been very complicated. So in the framework of the review, there is a scope for talking about that, but it's never easy, and the review has not started as well.
I think it's like when you mention it's totally like in connection with what we are discussing because I remember when we were talking about the peace clause in the pandemic accord negotiations and how some countries make a point of really scrapping any reference to this, and then there is like that anything in the pandemic accord needed to be mutually agreed terms and voluntary basis. It seemed like that there was an obsession of that. I think that it's really interesting as well in the sense that you see like there's this tension between compulsory licenses and voluntary licenses, like one seemingly more respectable than others. And I think that there's really like a message that is being sent to governments when there's all this pressure that it's like, you see, don't worry. Don't go the compulsory license way. Like just wait a couple of years and maybe hundreds of patients will have died by then. but then you will have a voluntary license and you will have access to this product. I think it's really interesting to see also, and I think in this sense, what Pramiti was saying, it's very clear, embodied by Colombia. I think when there's political will, there's a way, you see, and when there's a way, there's a light at the end of the tunnel. So it's just a matter of keep on pushing. And do we have like more questions, or maybe Pramiti and Thiru want to react to what Nicolas said?
I think I completely agree with Nicola. Also, what you said right now, that where there is a political will, there is a way. And to reiterate, yeah, I think this political will also needs many countries to come together and to then stick firm on the demands and the need for reform and review. And I think that we saw also when the TRIPS agreement was being signed itself, that's what happened in the beginning. Many global south countries did say that they didn't want IP and trade to be linked. But then eventually the US, the EU, other kind of global north countries were able to sort of wear this resistance down by putting trade pressure on agriculture, on other kinds of trade areas, etc. So I think there's really a need to kind of resist that trade pressure, which is of course much easier said than done. But to resist that trade pressure, South-South collaboration, I think, is hugely important. And the second thing I would say is that, again, to focus not just on what's happening in the TRIPS and at the WTO itself, but also outside at this kind of lower level of, but still hugely important avenue of regulatory influence, which is collaboration between patent offices. Because I think that that's a second sort of hidden, pervasive area of regulatory influence and wearing down of TRIPS flexibilities. And so that also needs equal attention as well. I think that's all from me.
Thank you, Nicolas, for your comments. And I think that specific case you mentioned, I think it's worth all of us really exploring to see its implications, for WTO members, and more specifically, perhaps in our context, access to medicines. And just one final thing. Yes, I mean, in relation to the what Nicolas mentioned in terms of the peace clause, yeah, I just posted some materials at the time when we were also observing quite closely the discussions on the peace clause at the WHO, and there itself you can more or less see which countries were in favor of including a language on the peace clause and which countries were against. I put that in the chat.
Thank you, Thiru. It's like a little bit like what we were saying about like the incoherence of like some formal expressions in the issue, like with flexibilities. Now it's pro forma to like acknowledge the Doha Declaration, even though then in practice you can see that there's like plenty of actions to really like not allowing other countries to make use of those flexibilities. I really like what Pramiti was saying about like the promise that was made to like developing countries on agriculture. And it's like 20 years and this has not changed yet. You see, there are still like promises, which I think it's quite telling. We are about to close this launch of the paper. I would like to thank Pramiti for like her really good work on this paper and also her performance today. Thank you. Also Thiru, like not only because he really like was focused on the issue, but also provided a lot of insight, and Nicolas for like sharing with us this first-hand knowledge. And I would like also to reaffirm like the importance of civil society in this area. Like we are living like very difficult times for independent and non-governmental organizations, public interest, civil society organizations. And I think it's good that we are still able to really like put these products out. You see, in the sense like high quality, evidence based papers that can inform the discussions, that can really advance in a constructive manner, like the discussions, and that we keep track of what's going on, like as Pramiti said, like at WTO, but also with what it was mentioning at WHO, at WIPO, and especially at the national level. So thank you, everyone, and also thank you, Alex Lawrence, our communications manager, for like making it possible. And let's keep talking, let's keep listening, and let's keep learning from each other. Thank you.
Thank you very much.
So much for all of your insights, and also Alex and Tim's insights, which made the briefing paper possible. Also, Nicholas, for taking out the time to speak with us. And Thiru, of course, for responding today.
Thank you.
Thank you.